Hello, everyone, and welcome back to the lecture series dedicated for the preparation of CLAT examination. In this particular lecture series, we are discussing about the important aspects and the different legislations one has to go through whenever they are preparing for CLAT examination. In this lecture series, we've been discussing about the important aspects and covering the whole syllabus, specifically focusing over the legal reasoning portion of the CLAT examination. In this lecture series, we have dealt with a lot of legislations, specifically focusing our mind according to the requirement of the CLAT examination. We have been focusing over uh, the law of torts. We have discussed the Constitution of India. We have discussed the criminal laws, and we have talked about the contract also. In the previous lecture series, we have been discussing about the family laws. The family laws they are very important when you talk about CLAT examination as such, because there will be questions encircling the important provisions of the family laws. Family laws are codified, and they have been put up in different legislations. For example, if you talk about marriages, it has been codified in the form of the Hindu Marriage Act. When you talk about succession, it has been codified in the form of the Hindu Succession Act. And if in the same way, if you talk about the adoption and maintenance, it has been codified under the Hindu Adoption and Maintenance Act of 1956, as it is available and visible over your screen. The first and the foremost thing that will come up in your mind is that, sir, we have been talking about family law. And when we talk about family law, what we need to understand here is that there are different aspects of family, different aspects of family. We need to understand that whenever we are talking about family, we are focusing not only towards the creation of only towards the creation of marriages here, but all the obligations that turns out post marriage needs to be addressed. So when you talk about family laws as such, you cannot simply codify a law which is only encompassing the important aspects of marriages only, but you will have to see through it that how the adoption under the Hindu laws will be taking place, how the maintenance needs to be provided, who all are entitled to maintenance. Entitled to maintenance. Now, when you talk about adoption, you need to know what exactly is the ground rule. Exactly is the ground rule? I still remember in 2015, if I'm not wrong, there was a question which was in relation to the adoption of a girl by a woman. So it was questioned that whether it is possible for a person who already has a child, can she be entitled to adopt another child of the same sex? So there are certain rules when you talk about adoptions as such. Adoptions, as you know, that it means to adopt a child for if needs to be, then what exactly are the rules that one has to take into mind? That is something which has been talked about and which has been mentioned under the Hindu Adoption and Maintenance Act. Now we need to understand here one thing. Then when you talk about the Hindu Adoption and Maintenance Act, again, this act is also specifically talking about Hindus. The same definition that we discussed while we were talking about the Hindu Marriage Act of 1955, the same definition that we were talking about during the Hindu Succession Act of 1956, the same definition has been mentioned here also for the Hindu Adoption and Maintenance Acts of 1956. So meaning all the Hindus that has been defined under the said definition of the legislature has to be entertained and discussed and now taken into consideration in the same way it has been mentioned under the Hindu Marriage Act 1955, Hindu Succession Act of 1956 and Hindu Marriage Act of 1956. Now, the first and the foremost thing that you need to understand is what exactly is adoption and what are the rules of adoption in regards to the Hindu Adoption Act. And then we will talk about maintenance. That, for example, if I'll give you an example for both the scenarios. For example, I'll give you a situation here that there is a person X. He, obviously, this person is a male, and he wants to adopt, and he's of 20 years of age. He wants to adopt a child of 16 years of age. And the child is a female. The question is whether X should be allowed to adopt a child of 16 years of age, which is a female, or whether it is necessary for X to be married to adopt a child. Another question that would come up in your mind is that what is the need of adoption? And how legislation is ensuring that the person who is going to adopt, if Hindu, follows the rules of HAMA. Now, what is HAMA? The Hindu Adoption and Maintenance Act of 1956. So, if you specifically understand here that the need of this particular legislation is not only to figure out the rules which are important whenever we are going to have adoptions, but first and foremost, we need to understand why exactly adoption is necessary, why exactly maintenance is necessary. Because when you talk about adoption, the first and the foremost thing we need to understand here is that when adoption is being talked about, it is an obligation. It is an obligation on a person to take care of someone who is not related through blood. So the first and the foremost, the reason for allowing adoption in the Indian society is that there are many examples, and it is not only specifically talking only about the Indian society as such. It is generally applicable for throughout the world, that whenever we're talking about adoption, we are taking into consideration the important aspects of the child who happens to be an orphan and who doesn't have a living mother or father. For that orphan, it is important for their upbringing and to have a status in the society that he be given enough opportunity and understanding, and because of which it will be feasible for him to stand up and to represent himself in the society and to become something which he obviously wants. So adoption gives this authority, or adoption gives this chance to a person who is not able to bear a child, because of medical problems, because of XYZ reasons. If they are not able to bear a child, they can adopt a child, they can upbring it, and after bringing it, obviously the child will be able to become a respectful person, or maybe he has some give towards the society. So Hindu Adoption Act only provides you the rules and regulations which needs to be fulfilled whenever there is a need, or if somebody wants to adopt a child, that how the adoption will take place, who is actually in charge of giving in the adoption, what are the requisites one has to fulfill whenever they are willing to have adoption, and foremost that particular person is a Hindu, then the Hindu Adoption and Maintenance Act will come into play. And in the same way, when you talk about maintenance, so maintenance is actually providing you the relief that you are not if not earning if you are not earning and you are dependent upon your parents, spouse, etc., then what are the conditions by which you can claim maintenance? So, for example, if there is a person X, who happens to be the child who happens to be the child of Y. Okay. Now, after the birth of X, Y disbandons him and doesn't take care of him. Doesn't take care of X. Now, X obviously will not be able to survive in the society. The reason being, obviously, there are lots of helps and assistance that is needed. And if the child is being disbanded, and if the child is being not being taken care of, then the growth of the child, his representation, and obviously his rights will be questioned. That is why it is the responsibility of the parents. It is the responsibility of the parents to maintain X until unless he comes to the age of majority. That is until 18 years, or he becomes major. Now, it is the responsibility, but now let's take an assumption that Y, instead of maintaining X, okay, abstains from maintaining or taking care of X. Now, what exactly is the remedy available for X? What exactly X could do in order to make sure that he has been given enough rights, or he's been given enough resources through which he will be able to cope up in the society and make a impact, and can develop himself and can be of use for the society. So for that, he need that there should be some sort of maintenance. There should be someone who can maintain him so that he can grow and he can prosper. The Hindu Adoption and Maintenance Act gives this right to all the dependents, whether be it a child, whether be it a wife, whether be it the parents, etc., to get maintenance from the person who has been obviously the father, the parents, etc., fathers, parents, etc., in order to get the maintenance, and obviously in order to grow and in order to get what exactly is their rightful authority. If they have the right, obviously that right needs to be entertained. So that's why the Hindu Adoption and Maintenance Act come into play. Let's try to understand what exactly are these sections talking about, so that you get a clear idea as to how the things has to be. So when you talk about, let's try to understand the index, or maybe the sections, the arrangement of the sections for a better understanding. Short title and extent, obviously you have understood, so we need not be going through that, because it is only the name of the section, that is Hindu Adoption and Maintenance Act. Application of the act, definition and overriding effect of the act, it is almost the same that we have discussed under the Hindu Maintenance Act of 1955 and under the Hindu Succession Act of 1956. The same definitions goes for the Hindu Adoption and Maintenance Act of 1956 also. Now, adoptions to be regulated by this chapter, that is obviously we are going to talk about adoption. Adoption under the Hindu Adoption and Maintenance Act starts from section 5 and goes to section 17. So this is something that you need to remember, because obviously if once you are able to recall the sections, it will be easier for you to remember what exactly has been mentioned in that particular section. So section 5 talks about adoption to be regulated by this chapter. Section 6 talks about requisites of a valid adoption. Now, if there is one person X and he by some manner adopts Y, this person is of 22 years of age, and he is a male, and this girl, she's a girl, and she's of 17 years. Whether this type of adoption can be made possible. Question is that whether this type of maintenance is possible, this type of adoption is possible or not. All these things we'll come to know when we'll be discussing about this particular legislation. Then the capacity of a male Hindu to take an adoption. That what are the requisites once a Hindu male wants to take an adoption, then what are the things that he needs to make sure that these are the capacity of that person or not. Then capacity of a female Hindu. Can a female Hindu take an adoption directly, or he needs consent from his father? All these things we are going to study. Then persons capable of giving in adoption. Who are authorized to give adoptions? For example, a person X, okay, he is a child of 5 years. Obviously, he has no knowledge as to what exactly is better for him, whether it would be good to be the son of Y if Y wants to adopt X, or whether it would be better for X to be the son of Z, who if Z wants to take an adoption of X, then to whom he should be given, whether it should be given to Y or whether it should be given to Z. Obviously, this is something which obviously X will not be able to figure out because he doesn't have that knowledge. Take an example that this child is of 2 years of age. 2 years of age, then whether it should be going to Y or whether it should be going to Z is something that is obviously questionable. So that is why persons capable of giving in adoption is also important. That if there is a person to whom who has been given the custody of the child, for example, orphanages, where which there are lots of children who are orphans who are living there. If they want that they should be given to some family members so that they can be, their upbringing can be there, it is the orphanage who decides to whom this particular child should be going. So that is why it becomes very important. It becomes very important to understand that who all are capable also of giving in adoption, that who will be taking care of the child, and after there is a person who will really wish to take in the adoption of that child, then how the adoption will be given by that person. Then persons who may be adopted. Okay, then obviously there are child and other things, other requisites that needs to be fulfilled in order to check that who can be given as a form of adoption. Whether a 42-year-old be adopted. Question. Whether a 42-year-old, whether be it a male or female, whether they can be adopted, that this question will obviously be answered when we will be studying about the section 10, which talks about person who may be adopted. Then other conditions for a valid adoption. What are the other conditions that needs to be fulfilled when you're talking about a valid adoption? Then what is the effects of adoption? Obviously, the effects would be that the child will now be under the custody of the person who has taken adoption. But what are the other requisites or the other effects of the adoption? That is something that we'll be discussing in our this particular lecture only. Then right of adoptive parents to dispose of their properties. Okay, so now the right of adoptive parents to dispose of their properties. So the property of a person, of a child who might have been given in adoption, he might have had a property. So whether it will be the right of the parents to whom the child has been adopted, how the property can be segregated, how this property can be managed. That is what we're going to discuss in our right to this particular adoption. Then 14 section talks about determination of adoptive mother in certain cases. And who will be the adoptive mother? That is something that we'll be questioning in our section 14. Then valid adoption not to be cancelled. Okay, so now if once adoption has been done, once adoption done, it cannot be undone. So for example, let's take an example. Ram takes in adoption of a child with the name of Chodu. Okay, for your better understanding, I'm just mentioning the name. Ram takes in adoption of a child with the name of Chotu, and after a certain period of time, Ram doesn't want to be the guardian of Chotu and he wants to cancel the adoption. It is not possible. Once an adoption is done, it is the responsibility of Ram to make sure until unless Chotu becomes major. And in certain conditions, even after becoming major, it is the responsibility of Ram to maintain Chotu. Okay. So another thing is section 16, which talks about presumption as to registered documents relating to adoption. This is very important. This is very important that how will you be able to understand whether adoption has taken place and it is correct or not. It is only through adoption that through the registered documents that you will be able to understand whether the adoption has been taking place in a correct form or not. And then prohibition of certain payments. Whenever there is a chances that there is any sort of payment which is done in order to make sure that adoption takes place, and if it is in the form of bribery, etc., then we will not allow adoption. We will not allow adoption. All these things we are going to study in detail now. So let's focus and let's start with the important legislations, with important sections which is talking about adoption and how adoption is going to take place whenever you're talking about Hindu as such. So the Hindu society or the Hindu community, how the adoption will take place in regards to the Hindus as such will be governed through the Hindu Adoption and Maintenance Acts. Let's try to understand the sections accordingly. Okay. Then we will be talking about maintenance, but that is something that we'll be discussing later on. But let's focus over the Hindu Adoption Act. Okay, so first thing we have already done. The same scenarios there. Second section are also the same. See, if you remember the Hindu, the Christian, legitimate, illegitimate, Hindu, Buddhist, all these things we've already studied in the Hindu Marriage Act and the Hindu Succession Act. So I won't be dealing it again. Okay. If you want to understand what exactly is the provisions, then obviously you can refer to the previous videos and you will be able to understand what exactly these 4-5 sections are talking about. So let's strictly focus over the adoption under the Hindu Adoption and Maintenance Act, which starts from section 5. Let's see what this particular provision is talking about. Adoption to be regulated by this chapter. No adoption shall be made after the commencement of this act or by or to Hindu except in accordance with the provisions contained in this chapter, and any adoption made in contravention of the said provision shall be considered as void. So if you want to adopt somebody, and you by virtue of your religion is a Hindu, then you will have to follow what? Follow what? It is Hindu Adoption and Maintenance Act of 1956. Okay, so this is important. This is important for you, and this is the main crux, or this is the main story of section 5. Section 5 says that adoption, if not regulated according to provision of HAMA, that is Hindu Adoption and Maintenance Act of 1956, shall be considered void. Void means void ab initio, means it never existed at the very first place. So no adoption shall be made after the commencement of the act or by or a Hindu except in accordance with the provisions contained in this chapter, and any adoption made in contravention of the said provision shall be void. So this is what is the important provision of section 5. So section 5 is saying adoption, if you want to do adoption, it has to be regulated through this particular legislation only, if you at all are a Hindu. Let's see what is the next provision saying. An adoption which is void shall neither create any right in the adoptive family in favor of any person which he or she could not have acquired except by reasons for the adoption, nor destroy the rights of any person in the family of his or her birth. So, if the adoption is not valid, if the adoption is void, like let's take an example. This is a person, I'm so sorry for my drawing, and he has to be adopted in a family. Okay, this is the house where which he needs to be adopted. Okay, now this consists of 5 members. There are 5 members, and if this person or this child needs to be adopted in this house, first and foremost thing, they have to follow the principles or the rules mentioned under Hindu Adoption and Maintenance Act. First thing, if they are not following the Hindu Adoption and Maintenance Act, and if by virtue they are a Hindu, then it will not hamper any right. It will not hamper any right or obligation of these 5 members which are there in the family, even by birth. It means that, okay, let's take the example. If this child, this adoption would have been valid, and this person, the karta of the head of the family, let's take the example X, wants to adopt this child. Now, after adoption, what will happen? That since now he will be considered as the father of the child, this X's property rights will also be going to this child. Yes or no? Yes. So once the adoption takes place, it provides a lot of rights and inheritance and share in the property of the person who is the adopter or who has adopted the child. But if before the adoption there is something which needs to be fulfilled and it's not been fulfilled, then the adoption will obviously be considered as void. Yes, according to the virtue of section 5. And it will make sure that there is no right that has been created in the family for the child if the adoption has been considered as null and void. And all the family members, whatsoever their rights were, will still be intact, and it will not destroy any rights of the person of the family where the adoption needs to take place. So that is what has been mentioned here. An adoption which is void shall neither create any right in the adoptive family, the family which I was just referring to, in favor of any person which he or she could not have acquired except by the reasons of adoption. Meaning which if that child would have gone to the family of that house, okay, if he would have successfully been adopted in the family, then this child would have got all the rights and obligation had that scenario that this child would have been born by birth in this house. So he would have got all the rights in the same manner as if he has been born in that house. But since now the adoption was void, so he will not get any right in the family, and nor the members who were already present in the family, their rights will get affected. This is what has been mentioned here. Could not have acquired except by reasons of adoption, that he would have adopted those rights. He could have acquired those rights only by virtue of the adoption, but since the adoption never took place, then he will be refrained from getting those rights, and not it will destroy the rights of any persons of the family in which he would have been there as birth. So any members' rights shall not be affected. So this is what section 5 is talking about. Now let's move forward and let's see what are the requisites of valid adoption, and how the adoption shall take place. So first and foremost, it starts with the no adoption means it is a negative section, because whenever a section starts with no, it means that if these things are not present, then the adoption shall not be considered as valid. So the first thing is, no adoption shall be valid unless the person adopting has the capacity and also the right to take in adoption. Okay, the person adopting has the capacity. So if you need to have a valid adoption, if you want to have a valid adoption, the first thing you need to check is the person who is adopting has the capacity. Now the question is, what capacity? So for that, we will be moving towards this particular section, and then we will come back to the section 6. Now, it is talking about capacity of a male Hindu to take in adoption. Now, here we were referring to and we were saying that the person adopting has the capacity. So now let's try to understand first what exactly is capacity here, and also the right. Obviously, the right will be there if he has the capacity to take in adoption. So let's try to understand what capacity means according to section 7. So section 7 says that if you are a Hindu male, okay, if you are a Hindu male and you want to take in adoption, then when it will be considered that you have a capacity? The first thing is any male Hindu who is of sound mind. So the first requisite is, if you want to talk about the capacity, the first requisite is, and if you're talking about male, the first requisite is sound mind. He should be of sound mind. Second, and is not a minor, has the capacity to take on or daughter in adoption. Any male who is of sound mind and is not a minor has the capacity to takes on or a daughter takes on or a daughter in adoption. Okay, provided that if he has a wife living, he shall not adopt except with the consent of the wife. The second thing is consent of the wife is important. If he is married, then the consent of the wife becomes very important. Consent of the wife. Consent of the wife is important requisite because whenever we are referring to the adoption, so adoption only takes place when obviously you are married, you are of sound mind, and if you want to take an adoption of a daughter, then you will have to take the consent of the wife. Then only it is feasible and possible to take an adoption. Okay. Unless the wife has completed and finally renounced the world and has ceased to be a Hindu or has been declared by a court of competent jurisdiction of unsound mind, then the consent of wife is not required. If the first thing is renounce the world, if the wife has renounced the world or ceased to be a Hindu or has been declared by a court of competent jurisdiction of unsound mind, if the wife is also of unsound mind, then you need not take the consent of the wife. Now, if a person has more than one wife living at the time of adoption, this is something which obviously you need not deal with, because now in majority of the scenarios you won't find that there are more than one wife, since because of when you talk about Hindus, it is only monogamy which has been followed. But even if, let's talk about the past when even Hindus are allowed to have more than one wife. So at that point of time, the consent of all the wives is necessary unless the consent of any one of them is unnecessary for any reason specified in the preceding proviso. What does it mean? What does that mean? That if she has renounced the world meaning she has said that I don't want to live the life according to the obligations of the society, and I don't want to be present. First thing. Second thing, obviously she has died. Second thing is she's of unsound mind. Then the consent is not at all necessary. Okay, provided that this is the first requisite of a capacity of a Hindu male. Now, when we talk about capacity of a female Hindu taking adoption, any female Hindu who is of sound mind and is not a minor has the capacity to take a son or a daughter in adoption, provided that. Okay, so here it is mentioned that it is not a minor, has the capacity to take. Now, this is actually, there is a mistake here. This is take son or a daughter in adoption. So, a Hindu can also adopt son as well as daughter. And in the same way, the female can also adopt son and a daughter. Provided that if she has a husband living, she shall not adopt a son or daughter except with the consent of her husband, unless in the same manner renounce the world or cease to be a Hindu or is declared by court of competent jurisdiction to be of unsound mind. This is now the capacity of the people who are going to take in adoption, the person adopting. So now when we talk about the capacity, it is clear that first he or she should be of sound mind, and second, they should be major. Major means above the age of 18. This is the Majority Act, the Indian Majority Act, which talks about the age, which talks about 18 to be the age of major. Okay, and has also had the right to take in adoption. Now, this is both for female as well as male. The person giving an adoption has the capacity to do so. So, who will be authorized to give the adoption? That is something that we will be understanding in the lecture, in the above sections when we're going to discuss. Now, these are the first two requisites. The third requisite is the person adopted is capable of being taken in adoption. Now, who will be adopted? What are the requisites to make sure that they are capable of being taken into adoption? And the fourth is the adoption is made in the compliance with the other condition mentioned in this chapter. So this chapter, which is providing you the other conditions that is needs to be fulfilled when we need to take adoption. So the first requisite, if we talk about condition, is that capacity should be there. Capacity of the person adopting. Second is capacity of the person giving in adoption. Third is capability of the person being adopted. And the fourth requisite is the rules. So this is the person who is adopting. So let's take it as A. This is the person who is giving adoption. So let's take it as, for example, orphanage A. And this is the child, capacity of being adopted. And these are the rules. So these conditions has to be fulfilled, that they should be adopter. There should be a person who is giving an adoption. And then the person who is being adopted. All these things, all these three things should be there. There should be capacity and the rules needs to be followed. The capacity of a Hindu male we have discussed, capacity of the Hindu female we have discussed. Now, persons capable of giving an adoption. So now who shall be considered to be given an adoption? First, let's try to understand. No person except the father or the mother or the guardian of a child shall have the capacity to give the child in adoption. Okay, so you must have seen different movies, Bollywood movies, where which you have must have observed that the child of the father or mother of a child, because of their incapabilities, because of they not able to manage themselves, wants their child to be adopted by their acquaintances, so that the child upbringing can be there and she or he could live a better life. So that is perhaps as best example for you to understand what exactly adoption here means. And the first condition is that no person except the father or the mother or the guardian. So these are the people who are considered to be capable of giving in adoption. So it is not like that if at all I have a child and I am not capable enough of maintaining my child. So what I do is I ask one of my friends who is willing to take my child as an adopted one. I want to adopt my child and wants to make sure that he takes care of my child in a very profound manner. So it is only by my consent that the child can be given in adoption. Child shall be the capacity of or the guardian of the child shall have the capacity to give the child in adoption. Second is, subject to the provisions of subsection 4, the father or the mother, if alive, shall have equal right to give a son or a daughter in adoption. Okay. Provided that such right shall not be exercised by either of them save with the consent of other, unless one of them have completely renounced the word. So it needs to be understand here that it cannot be made possible that only the wife or the husband alone goes for adoption. It cannot be that only wife gives adoption, only husband gives an adoption. It will, if the wife and the husband both are present, then both of them needs to give a consent mutually that they wish to give their child in adoption. Okay. Until unless, obviously, there is a requisite, there is an exception to it, that they have finally renounced the world or has ceased to be a Hindu or has been declared by the court of competent jurisdiction to be of unsound mind. Had that scenario not been there, then it should be the consent should be both of the husband as well as the wife, where both the fathers and the mothers are dead. Now, if both the fathers and the mothers are dead, this happens in most of the scenarios where which you find the mentions of orphanages. When both the fathers and the mothers are dead or have completely and finally renounced the world or have abandoned the child, or have been declared by a court of competent jurisdiction to be of unsound mind, where the parentage of the child is not known, the guardian of the child may give the child in adoption with the previous permission of the court to any person, including the guardian himself. Okay, so if you find out that there is a child whose mother and father has renounced the world, who is dead, and then it comes to the knowledge of court of competent jurisdiction that this particular child is in the custody and is being guardianed by some person. So even if that person by himself wants that this child should be his child, he needs to get a court certificate that he wants to adopt the child, and only after getting that certificate he will be entitled to be the valid guardian of that child. Okay, so this is the important requisite which needs to be understood when you talk about adoption. For majority of the people who might have seen the situations of adoption where which the father and mother both are not there, it is the orphanage where majority of orphans are there, and orphanage makes sure that if somebody wants to take an adoption of these childs, they, by the issuance of a competent authority, that is obviously the court, they will get the child adopted in the name of the person himself. Okay, or it can be the guardian himself, or it can be other person who are interested to take in adoption. But for that, the guardian will have to get a certificate from the court saying that this person in adoption with the previous permission of the court to any person. Previous permission of the court is important. Now the question is, which court? Which court? So the answer is court of competent jurisdiction. Competent jurisdiction. Now again the question comes up that what exactly is competent jurisdiction here? So competent jurisdiction means where which the child is actually residing. It will be decided according to the basis of where the child is actually residing, where the child has been found. For example, if the child is residing in Madhya Pradesh, and in one district of Madhya Pradesh, the court which is situated in that particular district shall have the jurisdiction to figure out that who shall be given the child be given as adopted to a particular person. It is the duty of the court to decide it, and only after giving the consent by the court, the person will be allowed to take in adoption. Before granting the permission to a guardian, unless under subsection 4. Now, what is the duty of the court? Before granting the permission to a guardian under subsection 4, the court shall be satisfied that the adoption will be for the welfare of the child. So what is the condition that needs to be fulfilled? Should be for the welfare of the child, due consideration being for this purpose given to the wishes of the child, having regard to the age and understanding of the child. Now, for example, if the child is 2 years of age, obviously the court will not take into consideration the understanding of the child. But had the child be of 12 years of age, then obviously the understanding and the consent and the regards wishes of the child will also be taken into consideration, and the applicant for the permission has not received or agreed to receive, and that no person has made or given or agreed to make or give to the applicant any payment or reward in consideration of the adoption except as such as may be sanctioned. Okay, so now it is very important. What happens is that you must have heard about human trafficking. You must have heard about people immorally trafficking persons from one place to another just for the sake of some money. And if you remember correctly, when we were studying about when we were studying Constitution of India, at that point of time we studied that human trafficking is actually null and void, and we have the fundamental right for the same. We have fundamental right of freedom also. and we have fundamental right of against human trafficking also. So what happens is that majority of the time the child who is an orphan, who doesn't have any guardian and parent, are vulnerable to be immorally trafficked, and that is just for the sake of monetary considerations. So if the court will allow such a scenario that the compensation or the payments be done in order to take in adoption, then there will be high chances that the people will adopt and then they will immorally traffic that person. So in order to make sure that these things are not there and the child wishes and welfare is taken into the paramount condition, the paramount condition is the welfare of the child here. Why do we take adoption? Why do we do adoption? For the welfare of the child. Welfare of the child. And that is why adoption is allowed. So if you're talking about adoption of a child, welfare of the child perhaps is very important. And in order to make sure that the child is being adopted, they have to understand that the welfare of the child is the paramount condition, and due consideration will be paid to the wishes of the child also and the age of understanding of the child also. And if the applicant is being allowed that he wishes to take an adoption, the court will see to it that there is no payment or consideration that has been made to the guardian for the adoption unless until the court sanctions it for the same. For example, when you talk about orphanages, what happens is that orphanages have made this understanding that they will be making sure that the child is being properly fed, the child is getting due amount of knowledge, they have been given good amount of shelter, good amount of food is there, everything is being taken care by the orphanages. Okay, so now whenever there is somebody who comes up and turns up to the orphanage and wants to adopt a child, they obviously charge a small amount of fees in order to run that particular orphanage. So that amount of payment obviously is justified and the court will allow it. But for example, there is one person who takes in who has ill motives, who has malicious intentions, who wants to do immoral trafficking, and for that he says to a person that if you want to adopt a child, you need to pay me 20 lakh rupees, and then only I will allow the court to make the name. I want. If you want to take my child, you will be allowed to take my child, but for that you need to pay me a remuneration of 50 lakh rupees or 60 lakh rupees. So that type of adoption is not actually allowed. I'll just give you the exact word, which will be helpful for you to understand. Just give me. I'll explain it to you. Yes. So whenever there is an adoption which is in the form of money or any requisites, then it needs not to be entertained at all. Okay. Now, for the purpose of this section, the expressions fathers and mother do not include adoptive father and adoptive mother. Okay. It is not like that you can say, and now it is my adoptive mother, so my father and my mother by themselves have given this consent. Okay. Guardian, what does guardian means here? Means a person having the care of the person or having the care of a child or of both his person and the property. Includes a guardian appointed by will of the child's father or mother, a guardian appointed or declared by the court. Court means the city, district, adopted legal event which has been ordinarily resided. Okay, so this is not for your benefit. No, that is not relevant for you. Let's move forward and try to understand the persons who may be adopted. Who all are persons who can be adopted? No person shall be capable of being taken into adoption unless the following conditions. First is he and she should be a Hindu. Second, he or she is not already been adopted. Okay, he or she has not been married unless there is a custom or usage applicable to the parties which permits that one take to be married. He has not completed the age of 15 years. Okay, unless there is a custom or usage applicable to the parties to take an adoption for 15 years in the adoption. Other conditions for a valid adoption: in every adoption, the following conditions must be complied with. If an adoption is of son, the adoptive father or mother by whom the adoption is being made, not having Hindu's son's son or son's son's son, whether the legitimate bloodship living at the time of adoption. So this is another requisite that needs to be fulfilled. If the adoption is of a daughter, the adoptive father or the mother by whom the adoption is made must not have a Hindu daughter or a son or a son's daughter, or whether by legitimate blood or relation present. It specifically means that if you are a Hindu female or Hindu male, okay, and you want to adopt a child, if you want to adopt a child, then the child gender should be such that you, the husband and the wife, should be such that the husband and the wife should not have any child of that specific gender. So if there is a husband and the wife and they have a son, they can adopt a daughter, but they cannot adopt another son. Okay, they can adopt a daughter, but they cannot adopt another son. If they have son and a daughter, then they are not allowed to inherit until unless they show to the world that the son and the daughter has renounced the world is of, see this one, if the adoption is being made by a male and the person to be adopted is a female. I just asked you this particular thing when we started with this lecture. What will be the answer? This, that there is a person X, he is of 22 years of age, there is a female Y, 17 years of age, whether this type of adoption is possible. Let's try to understand the answer here. Let's see what exactly the section or the rules are talking about in regards to the same. If the adoption is being made by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the persons to be adopted. If the adoption is by a female and the person to be adopted is a male, then the adoptive mother is at least 21 years older than the persons to be adopted. The same child may not be adopted simultaneously by two or more persons. The child to be adopted must be actually given and taken in adoption by the parents or the guardian concerned and or under their authority with intent to transfer the child from the family of its birth. Or in the case of an abandoned child, parent is not known from the place or family where it has been brought up to the family of its adoption. Family where it has been brought up to the family of its adoption, provided that the performance of datta home shall not be essential to the validity of the adoption. Okay. Now, what is the effect of adoption? An adopted child shall be deemed to be the child of his adoptive father or mother for all purpose with the effect of the date of adoption from such ties at the assembly, and she will be deemed to be replaced by the characters of the adopted family. Okay. So now we have tried to understand that what exactly adoption is, who is actually authorized to give an adoption, what are the requisites that is essential when you talk about adoption in regards to how the adoption will take place, who is authorized to give an adoption, who is authorized to take an adoption, and who is authorized to be adopted. The conditions that is required when you talk about adoption, the person who may be adopted should not be at the age of 15, meaning which any person who is below the age of 15 can only be adopted. If there is a Hindu male who wants to adopt a female, then there should be an age difference of 21 years. If there is a Hindu female, and he wants or she wants to adopt a Hindu child, then of a person male child, then the age difference should be 21 years. Then there are other requisites that we have already studied. So that is how the whole adoption is going to take place, and these are the conditions that requires to be fulfilled whenever we are talking about the adoptions as such. Okay, and effects of adoption, this is completed, provided the child cannot marry any person whom he or she could not have married if she had continued in the family of his or her birth. Okay, now this one condition needs to be understood very importantly. So for example, if there is one child and this is the family from where he has been adopted. Okay, this is the family, this is the father, and this is his adopted father. Okay, so this child shall not be allowed to marry any person from the family of his original father, and obviously to the family of his adopted father. The child cannot marry any person whom he or she could not have married if he or she had continued in the family of his or her birth. Any property which is vested in the adoptive child before the adoption shall continue to vest in such person, subject to the obligations, if any, attaching to the ownership of such property, including the obligation to maintain relatives in the family of his or her own birth. The adoptive child shall not divorce any person of his estate which vested in him before the birth. Shall not divorce any person of any estate which vested in him or her before the adoption. Okay. Right of adoptive parents to dispose of their property. Subjected to any agreement to the contrary, an adoption does not deprive the adoptive father or the mother of the power to dispose of his or her property by a transfer inter vivos or by a will. Okay, so adoption by themselves does not create any inheritance in the properties as such until it has been mentioned by a testimony will. Determination of adoptive mother in certain cases where a Hindu who has a wife adopts a child, she shall be deemed to be the adoptive mother. Where an adoption has been made with the consent of more than one wife, the senior most in marriage among them shall be considered to be the adoptive mothers other than the stepmothers. Where a widower or a bachelor adopts a child, any wife whom he subsequently marries shall be deemed to be the stepmother of the adoptive child. Where a widower or an unmarried woman adopts a child, any husband whom he shall marry subsequently will be called the stepfather of that particular child. Valid adoption need not be cancelled, that we have already studied, that once adoption done, it is done. Presumption as to registered documents, that there should be presumed that they have been made compliance with the provisions of this act unless this has been disproved. So whenever there is adoption, the court will presume the adoption is valid. The court will presume the adoption is valid until the documents being shown that the adoption is not valid. So this is how provision of certain payments. I have just informed you that no person shall receive or agree to receive any payments or rewards, consideration of adoption or any other, shall agree to make or give any other sorts of persons any payments or reward, the receipt of which has been prohibited from this particular section. So this is an important provisions in regards to the adoptions of the Hindu male or female by a Hindu male or female. Okay, so the conditions that needs to be fulfilled has been mentioned in the different provisions. I've just tried to explain you the whole provisions as such. It starts from section 5, ends at section 17. And what is the capacity of Hindu female? What is the capacity of Hindu male? Who is allowed to take in adoption? Who is allowed to give in adoption? What are the requisites that needs to be fulfilled? What is the court obligation? All these things has been discussed in a detailed and a crisp manner for your better understanding. So I hope that whenever there will be any question in regards to the Hindu Adoption Act in the CLAT examination, you will be able to answer it in a very crystal clear and precise manner. With this, I would like to thank you all again for being present in this particular lecture series. In the next lecture, we will be talking about the maintenance, and we will be discussing about that who all are dependent and why is it necessary to have maintenance as such. Maintenance will help you to understand that what are the obligations over the seniors, over the father and the mother or the parents to maintain a child. Obviously, it is also on the husband to maintain the wife, and that all the conditions that needs to be there according to the Hindu Adoption and Maintenance Act only. So in the next lecture, we'll be talking about maintenance as such. With this, I would like to thank you all again. You take care, be consistent, we try to analyze the provision that we have studied today and try to figure out that how exactly the question would be put up in front of you by analyzing the previous year question papers and mock test papers, which will be helpful for you in grasping that how the Hindu Adoption and Maintenance Act questions will be put up in CLAT papers for a better approach. And once you will be able to analyze it, that how the questions will be there in regards to Hindu Adoption and Maintenance Act, it will be feasible for you to understand that which provisions becomes important and what are the important essentials that you need to remember whenever you're going to whenever you're going to give this examination. Okay guys, thank you so much again. Bye bye, take care.